This is Colin O'Keefe for LXBN TV. The Supreme Court heard oral arguments today on whether or not the state of Virginia can block out-of-staters from using its Freedom of Information Act to gain access to state documents. Joining me today after attending those oral arguments is Kevin Goldberg of Fletcher, Hildreth, and the CommLawBlog. Kevin, first off, give us some quick background on the case, and also, how did the oral arguments go?
Well, this got to the Supreme Court because both of the lower courts, a United States District Court in Virginia and the United States Court of Appeals for the Fourth Circuit, ruled in favor of the state, saying that two separate applicants, requesters under the Virginia Freedom of Information Act, were not entitled to use the act because they were not residents of the state. And so the issues teed up before the court today were really twofold. And it's really kind of funny because when you think about it in that perspective, it's kind of a cool case. It's like, is the state really going to say nobody but its own residents can use the Freedom of Information Act? But when you get down to it, what the court was really hearing were constitutional issues involving what even I'll admit are like the less sexy constitutional issues. Whether this actually violates the Privileges and Immunities Clause of the United States Constitution, and whether it violates what they call the Dormant Commerce Clause. And so the court had to look at both of those issues. Number one, whether access to records is a fundamental right, and therefore discriminating against people who are trying to exercise that fundamental right violates the Privileges and Immunities Clause. And the court none of the justices seemed to really buy into the fact, unfortunately, that access to records, especially statutory access to records, is a fundamental right protected by the Constitution. However, they seem much more energized on the Dormant Commerce Clause issue, whether or not the access to records is something which affects commerce among the states and therefore can't be, the subject of discrimination. And I think this was really important. And it was really interesting because it seemed to me that the attorney for the requesters pushed that direction, especially the commercial aspect, knowing that a lot of the conservative justices might be moved if they understood that business, like free market businesses, could be impacted because they couldn't do things that in-state competitors could do. So there was a lot of discussion because Virginia, knowing this was going to be an issue, the Virginia attorney tried to position himself by saying, well, this is really not a commercial issue, it's a political issue. The Freedom of Information Act in our state applies solely to allow residents of the state to oversee what their government is doing for or against them. And so that was the first issue under the Dormant Commerce Clause side was really, is this commercial or is it purely political? And I think a lot of the justices actually lean toward the commercial. The second issue then becomes whether the impact on non-residents rises to the level of discriminatory. And Virginia was saying, well, it's really burdensome for us to deal with non-Virginia residents. So we have a real reason for separating the resident requesters and the non-resident requesters and favoring the resident requesters. Now, the requester side was arguing, well, you're going to be processing these requests, creating these records, storing these records, doing everything anyway. What you're really doing is unfairly burdening, almost taxing non-residents in a way that discriminates against them. Okay, so, I'm a bit of an amateur predictor. I can't resist it, whether it's sports or the Supreme Court. I write a column on CommLawBlog we call the Swami, where I do predict whenever I go to the court to watch oral arguments. And so I'll give you one here. I see this coming down as 6-3, overturning the law because it violates the Dormant Commerce Clause. And I see the three justices that are actually in dissent being Justices Alito, Thomas, and Scalia. I think all three of them would say this is perfectly legal for the state of Virginia to do, whereas the other six justices say, no, this is too unfair a burden on non-residents.
What are your thoughts on how this fits into the current landscape of open government, and just how impactful could this be?
Well, it's actually could have a very big impact. I mean, what's interesting is I got involved in the case because one of my clients filed an amicus brief at the Court of Appeals level, urging the case to take the court after urging the Supreme Court to take the case after an adverse ruling from the Fourth Circuit, and then again on the merits of the case. And that client was the American Society of News Editors. Journalists could be greatly impacted. I mean, if you are a journalist, there is an exemption for broadcast media from outside the state who have a reach into the state, or newspapers of circulation in the state. But if you're, say, the Baltimore Sun, who doesn't have, one would suspect, a really large circulation in the state of Virginia, you're not allowed to use the Virginia FOI law as a direct requester. You have to hire somebody to make requests for you and then bring the records to you. Now, I mean, there are any number of ways in which journalists specifically and others might use laws. I mean, one of the plaintiffs in this case, one of the requesters, was a national sort of commercial requester. He requested a lot of records related to property records, tax records, mortgage records, and use that data for his business purposes. But journalists are going to request records amongst all the states, trying to compare different things that are going on in different states. Journalists, for instance, in Maryland might want something specific only to Virginia. And recently, we had a murder trial here in the greater region where a University of Virginia men's lacrosse player killed his girlfriend, and he was brought up on murder charges. He was from D.C., she was from Baltimore. Her hometown paper, under this law, could not have requested records from law enforcement agencies about the case. That's a big deal to them. Okay, so this has potentially national ramifications for everyone, from businesses to journalists to individuals. It also might allow other states to follow suit. Right now, Virginia is only one of 3 states with the citizens-only requirement. I mean, if I'm one of the other 47 and the Supreme Court rules in favor of Virginia, you could see 47 more laws take this on. Right? So it is a very big deal, and it would just be another hurdle to those trying to get easy access to records of the governments that are supposed to serve them. I mean, the records that are supposed to be owned by them. I wrote something earlier this week on our blog about an attempt at the federal level to exempt the Federal Communications Commission from the requirements of the Government and Sunshine Act, which is the Federal Open Meetings Law. Why? Because they found it too burdensome. Well, that's very similar to Virginia's argument here. It's too burdensome to give records to non-citizens. Well, it's also very important, and it's a very fundamental part of our democracy to have access to records and to meetings. And I'm really scared that every hurdle makes it easier for government to evade sunlight and scrutiny.
And what's interesting and dangerous, I think, about this case is that the exemptions that you mentioned apply only to print newspapers and to broadcasters without any consideration for online publications. That seems like it has some major implications in today's evolving media landscape.
Yeah, and that was where we came in on the case. And as I said, if you go with the idea that the Dormant Commerce Clause issue sort of carries the day, well, then it's going to be decided without reference really to the journalism aspects or the public interest aspects. But hey, from my perspective, if we were to get a win and the law is overturned and non-citizens can request records, I'll be happy no matter how it comes.
As a proponent of more transparency in government and a journalist myself, I hope your prediction is indeed correct. Again, that was Kevin Goldberg of the CommLawBlog. For more of his insight on this story, be sure to visit CommLawBlog.com. And of course, for more video interviews from LXBN TV, along with curated commentary from the LexBlog Network's thousands of authors, be sure to visit us at LXBN.com.